Do you have the facts for primary physical custody? Well, first, let me start by explaining again what would constitute primary physical custody. Primary physical custody would mean that you have at least 60% of the time with the minor child, which essentially equates to 219 calendar days for the entirety of the year. Anything over that 60% threshold would gain the primary custody designation. And it's important to note that that could be 61% or 98%. It still carries the same classification of primary physical. Do you have the set of facts to persuade the court away from the presumption that joint physical is best for the minor children? Some of the things that the court would be looking at in that scenario is whether the other side doesn't have the mental or physical ability to care for the child on an equal timeshare set. Could that include drug or alcohol addiction to the point that it could affect their ability to have unsupervised or extended time? Yes, that could be one of the facts. However, it's also important to note that if a parent drinks or uses marijuana, it does not automatically preclude them from having a custodial set of time with the minor child. It is typically used as a persuasion factor if it is to such a degree that it would essentially eliminate or affect their ability to have extended meaningful contact with the minor child. And how do we differentiate that? Often is part of a custody case wherein we look at previous history, whether there's multiple DUIs or arrests relative to drug or alcohol use. If we have a parent who is drinking wine occasionally or has a drink and they go out on a happy hour and that is shown in their social media, the court isn't going to care that that is enough to persuade them away from joint custody.